Okay, let's unpack this. We often talk about big court wins, big losses. But sometimes the real story in corporate law is, well, the strategic retreat. And today we're diving deep into a really significant reversal involving one of the biggest names out there, Disney. They're facing a wrongful death lawsuit, and after initially pushing to handle it privately, they suddenly switched gears. They've agreed to a public trial.
Yeah, it's more than just a simple procedural step. It's really a fascinating glimpse into corporate risk assessment and just how much public relations can shape legal strategy. So our mission today is to really analyze this shift. We need to look at the suit itself. The details are serious, filed by a widower. We need to understand why Disney first went for mandatory arbitration, and then crucially, why they dropped that effort, and what this whole thing means really for online content safety and the accountability of these huge digital platforms like Disney Plus.
And the core claim, it's incredibly serious. It's actually quite shocking when you connect it to a brand like Disney, built on, family trust. A widower is alleging his wife's death was directly caused by her taking part in a promotional contest, a contest linked somehow to Disney Plus content. Now, the exact links, the specifics connecting the contest to the tragedy, those aren't fully public in what we've seen, but the central charge is negligence. That Disney's contest, its rules or its design, created a deadly risk.
Right. And what's really key here is understanding Disney's first move. They're almost a knee-jerk reaction. Their legal team jumped right in, moving to compel arbitration. Now, for listeners familiar with those, endless corporate terms of service, arbitration is standard stuff. It's a private way to handle disputes, keeps things out of the public court system, generally faster, cheaper for the company.
And definitely more private. They wanted this kept quiet.
Exactly. And we should probably dig into why corporations like it so much. It's not just speed. Arbitration often heavily favors the company. Why? Because discovery, that's the legal process for gathering evidence. It's really restricted. You can't just launch these broad investigations digging through internal emails, safety reports, marketing plans. Plus, there's usually no right to appeal. And the arbitrator, often a professional who gets paid repeatedly by the same corporate legal teams. So yeah, the whole system is kind of set up to limit the plaintiff's power and keep things secret.
Okay, that makes total sense from let's say, a purely financial and secrecy standpoint.
Great.
So if arbitration is the go-to corporate safe zone, then abandoning it, choosing a public trial, that seems almost counterintuitive. Why make that kind of dramatic U-turn? Isn't arbitration always the safer bet for them?
Well, normally maybe, but not when the case itself is this potentially damaging, this toxic, you could say. Look, arbitration might save cash and ensure privacy in a normal contract dispute. But this is a wrongful death lawsuit tied to a promotional activity run by a company whose entire brand, everything they sell, relies on being seen as trustworthy, safe, family-friendly. Critics were already loud, saying Disney's move to force arbitration looked bad, like they were trying to silence a grieving husband and hide the facts about a death linked to their own promotion.
Oh, okay. So the calculation changes. It's not just financial risk anymore. It's massive reputational risk. They figured the PR damage of fighting for secrecy, this specific tragic situation, was actually worse than the potential financial hit of losing a public trial. So they're trading, legal certainty for trying to manage the damage to their image?
That's exactly the insight here, I think. The reversal strongly suggests Disney decided their public image takes less of a hit by letting this proceed openly, even if it means facing a jury, potentially a huge verdict. It's better than being seen as this giant corporation actively blocking a family from seeking justice in open court. It's almost like a strategic PR gamble wrapped up as a legal concession.
Right. Now let's shift focus a bit. What about the implications for the plaintiff, the widower? This move to public court, it's obviously a win for transparency. But what specific legal edges does it give him beyond just, the public eye?
The biggest one is access to full discovery. And we need to unpack what that really means. In a public wrongful death suit, the plaintiff's lawyers can issue subpoenas, they can demand documents, they can potentially uncover internal corporate discussions. We're talking emails maybe between the marketing folks who designed the contest and the lawyers who approved it. We're talking safety assessments. Or, maybe even more damaging, proof that safety checks were never even done. That kind of exposure. That's what keeps corporate legal teams up at night.
I see. So in private arbitration, maybe they get a few basic papers. But in open court, it's like they potentially get the keys to the whole internal filing cabinet. And it's not just the documents, right? They get a jury.
Precisely. A jury trial completely changes the game compared to arbitration. A jury is, regular people, peers. They're likely to respond to the emotional core of a wrongful death case, negligence, loss, the need for accountability. An arbitrator, they might be more focused narrowly on, say, contract language, less likely to award huge punitive damages based on emotion or outrage. So for a plaintiff, especially in a negligence case seeking significant damages, a jury is almost always seen as a much better path.
Okay, that raises a practical point, though, maybe a bit cynical. Isn't a public trial way more expensive and slower for the widower, too? Is this really a win in terms of just time and money? Or is it mainly a win because it gives him more leverage and public pressure?
Oh, it's absolutely a win for leverage. Yes, public litigation takes time, costs money, but the goal for the plaintiff's team often becomes expose the negligence so thoroughly during discovery that Disney feels forced to settle for a very large amount before it ever gets to a jury. By dropping arbitration, Disney has basically handed the plaintiff the tools to make not settling incredibly costly for them. The pressure just ramps up exponentially. It suggests Disney knew they couldn't win the secrecy battle, so now they have to try and minimize the financial fallout from full disclosure.
And if we zoom out, connect this to the bigger legal landscape, this case feels like it could become a benchmark, right? The very fact that Disney felt it had to open itself up to this kind of public scrutiny, that must set some kind of new baseline for how other big digital platforms handle these kinds of risks. What sort of precedent are we potentially looking at here?
Oh, this case will be watched very, very closely across the entire digital content world. It really has the potential to fundamentally redefine what's considered the standard of care for online contests, for interactive digital promotions. In the past, companies might have felt pretty safe behind their mandatory arbitration clauses, thinking they could handle any negligence claim quietly. This Disney reversal kind of shatters that assumption.
So what does that mean specifically for, say, streaming services? They're all pushing beyond just passive watching, right? We see more interactive content, user challenges, contests tied to launching new shows.
Yeah, it raises huge questions about the ultimate responsibility of Disney and, by extension, any digital platform for these promotional strategies. It means the marketing team, the creative side, the legal department, they can't just operate in their own bubbles anymore. Before launching any new interactive thing like, I don't know, a physical challenge tied to a superhero show or some survival contest for a nature documentary, platforms are now going to have to conduct much more rigorous safety risk assessments and, crucially, document them heavily.
That really seems like the core takeaway for corporate compliance, doesn't it? It's not enough just to have that fine print arbitration clause anymore. You have to be ready to actually prove you did your homework, your due diligence, potentially in open court. Does this thinking extend to things like user-generated content challenges or even influencer campaigns run on the platform?
I think it absolutely does. The potential reach of this precedent is broad. If a platform encourages any kind of active participation, UGC, challenges, dares, whatever, and someone alleges harm resulted, this Disney case is going to be brought up as evidence that the company knew about the potential for public scrutiny, knew about the risk of large jury verdicts. It forces much tighter integration between creative marketing and legal approval than maybe we've seen traditionally. It forces platforms to really own the potential real-world harm their digital stuff might even accidentally encourage. It demands vigilance across the board on safety protocols.
Okay, so if we boil all this down, what's the single most important takeaway for you, the listener, from this deep dive into Disney's strategic move?
Well, I think the key takeaway is pretty straightforward. This decision marks a profound corporate recognition, a recognition of the huge cost tied to avoiding transparency when negligence is claimed in this digital age. They basically conceded that the PR cost of fighting for secrecy and the risk of having their internal decision-making exposed was ultimately more damaging to their long-term brand health than the financial risk of an open trial. It's really a win for accountability, interestingly, forced not by some new law, but by the power of public image.
Yeah, that really gives you pause, doesn't it? If a company as massive, as legally sophisticated as Disney has to rethink its whole approach to promotional safety and documentation just because of the threat of having internal memos surface in discovery, well, what does that suggest about the level of scrutiny maybe all of us should apply to those everyday online contests, those free digital things we click on all the time?
Yeah.
Are we really looking critically at the rules, at the potential risks when we hit participate, or are we just, hoping to win the prize? Definitely something to think about until our next deep dive.